segregation to desegregation to resegregation. And
right.
there's some risk that that's exactly what has happened socially.
You've got the west side and predominantly black, and the east side predominantly white, as it's typically described even still today.
Yeah, with various ethnic groups.
Correct.
We talk about the Emerald City of the Land of Oz, and there's a part that's red over here and yellow over here.
Yes. What's good? Welcome to Retrial Podcast. I'm your co-host, Judge Gerald Parker, along with my friend, colleague, attorney, and Dayton legal historian,
Dave Greer.
We're excited about this first episode. We're going to be discussing the Dayton school desegregation cases, specifically these cases that lasted from 1972 to 1975. We'll take a look at both sides of the case, their strategy, and ultimately the decision that impacts our present day realities. Before we get into the actual litigation and the case, Dave, we're going to start in the 1960s. From what I understand, I wasn't there, but the 1960s were somewhat of a turbulent year, right?
Turbulent bunch of years, yes, and I was there, yeah.
That decade seems to be something that when I look at, I'm like, wow. People say today, from 2020 on, they're like, we're more divided than we've ever been. I'm like, except for the time period that was known as segregation. I don't know if that seems to be a little bit more divided.
Lots of time periods that fall into that category, unfortunately.
Yeah.
And if we start in the 60s, that's about 10 years after Brown versus Board of Education. Mm-hmm. And the tensions had been mounting and continuing all over the country as the whole country was enwrapped in desegregation issues. Where I like to start our point here, as you said, in the 60s, there's an old blues record. Leroy Carr was a Indianapolis blues singer, very haunting voice, wonderful singer. He put out a record that has a start to it that I think starts where we really hit the wall here. It goes, in the wee morning hours, just before the break of day, the blues grabbed my heart and carried it away.
Wow.
And in the wee morning hours of September the 1st of 1966, a gentleman named Neil Bradley Long, white man, lived on the east side of Dayton, got in his car, drove across one of the bridges that takes you to the west side of our city. He had a passenger in his car. The passenger was a shotgun. The passenger's window was opened with the barrel of the gun sticking out the window. With that, put the trigger right down where he could reach down from the steering wheel and pull the trigger. He drives into the west side in the darkness of early morning hours. There's, as fate would have it, a black man standing on a street corner on 5th Street. As he drives by, he reaches down, he pulls the trigger, blows the man to bits. Circles around, goes back over the river, back to the east side of Dayton. That shot triggered off what we remember as the Dayton race riots, which were a horrendous several days. 175 people in jail. Most of the west side essentially destroyed. It was just a nightmare. National Guard on the streets. The mayor of Dayton, Mayor Hall, in tears with a quivering voice trying to calm the crowds. National Guard everywhere. It was a terrible scene. And that added kerosene to the fuel or the flames that had been flickering since Brown versus Board of Education in Dayton as elsewhere. And of course, Dayton was as segregated a community as you could find in the United States.
Yeah, we hear a lot about the race riots you hear Watts and Detroit and Harlem and things of that nature. But right here in Dayton, I believe we had a visit from George Wallace. Is that correct?
Yes, we did. And as time went on in the 60s, we had quite a war going on between the Dayton Police Department and the Black Panthers. Mm-hmm. The Black Panthers had a rally here, 700 people on the courthouse steps.
Right.
So the the decibel level was going up on all sides.
And then, of course, the assassination of Martin Luther King Jr. and then Robert Kennedy couldn't have just
68,
made it.
right.
Jeez.
So it's all building up. And in addition to the hostilities you've got between the races in the community, you've got a sharply divided school board, a liberal group and a more conservative group. The liberal group, as they're voted out in a general election, do a lame duck resolution that would integrate every school in the city of Dayton, not just by race, but by economic status. So poor, rich would be divided up that way. And of course, the new school board changes the complexion, and they rescind that resolution.
I think it's important for everyone to know, what got you involved? Like, how did you say, all right, I want to be a part of this?
I got hired. That's how lawyers. That's how lawyers get involved.
Yeah.
And there was a fascinating legal question in this case, which is why it was in the courts for a decade. From a lay person's viewpoint, if you see a school that has all black students and the school next to it's got all white students, there's something wrong with that.
Right.
That sounds like segregation, and it is. We had very segregated schools. But the issue really legally was, is that something that the school board did, or did that happen from private causes that are not responsible under the Constitution? In addition to equal rights and due process, we have freedoms of assembly, we have freedoms of speech. That's why you can hear a lot of idiots talking on TV and saying a lot of things you wish people wouldn't say.
One of the questions I have to ask, if this is the Dayton desegregation case, and we filed, these cases were filed in 1972, Brown versus Board of Education was 1954. I thought Justice Earl Warren said with all deliberate speed, why are we almost 20 years later? And also we're filing this case in the city of Columbus, not Dayton.
Well, the city of Columbus thing is easy to explain. There was so much violence, threats of death and threats of violence going both ways, white to black and black to white, that the court decided we can't try this case in Dayton. We got to move it up to Columbus.
All right, well, let's take it to Columbus then.
But then why the gap between Brown versus Board of Education and the Dayton case? It gets us into the subject of what the NAACP strategy was. And it was an excellent legal strategy. Thurgood Marshall started with it, as you know. You go back in history, and it was a step at a time. First, proving that facilities are inherently unequal if blacks are treated different from the way whites are treated. And then they moved Arkansas, states where the statutes of the state had required separation of the races in schools. So if that's an act of the government, and that's the government saying we're going to segregate the races, and that was true throughout the South. So you went through that wave of cases, and the reason that the next step in the strategy hit the Sixth Circuit, which is where Dayton is located, was that the Sixth Federal Circuit is the only federal circuit that is a north-south circuit. It encompasses Michigan, Ohio, Kentucky, and Tennessee. In Kentucky and Tennessee, there were long-standing statutes that required segregation in their schools. Those cases were easy after Brown versus Board of Education. It's state action. State action has to be shown to violate the Constitution. They had them. That means that the judges of the Sixth Circuit, who came from Tennessee, or from Kentucky, had to go home and talk to all their constituents who were angry about desegregation. And then if they treated the North two states differently, they've got a lot of splaining to do.
Yeah, that's right. Because
the average human being, if you see a school that is a segregated school, you think, well, that's wrong. Shouldn't happen. But unfortunately, the Constitution works. It's got to be state action. to make it a constitutional violation. And that's what made Dayton a kind of a pivotal case in the history of this stuff.
What seems to get kind of muddied is, de jure versus de facto segregation in these cases. And so all the cases that have been litigated after Brown versus Board of Education, de facto, in fact, you see the segregation taking place, and then de jure by law. But at some point, if there's laws that are inherently created in order to segregate individuals, schools, resources, it would seem as if factually that's going to wind up happening later on anyway. So, were you able to, and you were able to argue and litigate this case before the Supreme Court? Is that accurate?
That's true, twice.
Twice before the United States Supreme Court. You've got this Ohio River, of course, separating Ohio and Michigan and the Sixth Circuit, and of course Tennessee and Kentucky to the south. And then there's this muddying of waters with de jure and de facto. So how are you able to, and sort of the Supreme Court helps sort that out, but in Dayton particular, and taking it to the district court, making those arguments and trying to understand, was it the resources that were lack of being provided, the teachers, the students, the busing, was it all encompassing of anything that was being done in order to create this dual school system?
Well, the interesting thing about it is that the Board of Education did nothing. The argument was that they had between two different schools, they would have optional attendance zones. Mm-hmm. So if you lived an equal distance from this school and that school, you could go to whichever one you wanted to.
Right.
And the argument was that was arguably an act of segregation. There were anecdotal things that sounded like acts of segregation. Mm-hmm. Roosevelt High School, one day the blacks could swim in the swimming pool, and another day the whites could. And there's a lot of anecdotal stuff that went on. Dunbar High School was founded in 1933 as an all-black high school.
The Wolverines, shout out to the Wolverines, right?
And the argument was made that that was an act of segregation. In fact, historically, the reason Dunbar was founded was at the request and urging of the NAACP, because it was the theory that black students would, if they had black mentors teaching them, would have a better chance of succeeding in society. So no good deed goes unpunished. Right. And in fact, far from drawing students, black students out of Roosevelt High School, Roosevelt High School started out as a white school, slowly evolved as housing patterns changed to a mixed school, white and black, to essentially an all-black school. Same happened with Colonel White and another high school in town. So that you could get mad at the school board for sitting idly by and in benign neglect of doing anything proactive. Right. But they did nothing proactive to cause problems. The first case was kind of national. The first trial up in Columbus, which took November and December of '72, was kind of National White Hate Week. Right. And you really felt sorry for all these people who had built up all these things that had happened to them as human beings, and let them all loose in the courtroom. And hopefully it had some cathartic effect, but it was kind of shocking to a guy like me who'd known a lot of these people as school administrators and people that I've worked with at the United Way or this or that, who had been a joy to work with, beautiful people, suddenly in a state of total rage and outrage at what had happened during their lives. Yeah. I think the Phyllis Greer story.
I was going to say, I was actually about to go there because you tell an amazing story about Phyllis Greer. No relation, right? Phyllis Greer?
Not that I know of, but one never knows.
I guess. Phyllis Greer, a young black student who, I guess, all of the Christmas characters for the Christmas pageant, Christmas play were taken except for an angel, and she wants to be the angel. And the teacher says, you can't be an angel because there's no black angels. It's those little anecdotal stories that people don't think about. I have to pivot because I have to tell this story. When I grew up, my mom collected black Santas. Okay, it's December right now as we record this. It's all black Santas. So we had about 60 black Santas in our home. and she got them from, I think, Macy's and some other places. And it was just funny watching some of my friends, particularly my white friends, come over and they see all these black Santas around the household. And there's always this one little white Santa just sitting there. And I always wondered what was going in their head because all these black Santas all over the place and this one white Santa. It was just fascinating. And I think about that when I see this story. Those stories and other stories that were intricate and people probably have their own, I know people have their own stories and sagas coming up through Dayton Public Schools, particularly during the desegregation cases. You wrote something in your book, Stuff of History's Boot Soles. I have to mention this, what you wrote about litigation in general, particularly during this time. You said it can be argued that all litigation is just a civilized displacement of mayhem and warfare. And that the decade the case spent in the courts, meaning this desegregation cases, permitted time to heal wounds that would have otherwise been unhealable. The case kept the community occupied in a ritual confrontation and cleansing that would otherwise have made its schools and its streets unimaginable. In the long sweep of time, the experience should lead to better educational opportunities and mutual understanding. And all that kind of sounds like 2020, to be honest with you, with what would happen in 2020 and moving forward.
Well, unfortunately, I was a little more optimistic when I wrote that than maybe I should have did.
Right.
And I guess we'll get to that kind of at the end of our discussion this morning. But to go back to who the players were and how this case played out, the strategy was dictated by the NAACP from New York. Nathaniel Jones was the general counsel and ultimately became an honorable member of the Court of Appeals of the Sixth Circuit. He did not participate in the actual trial. The actual trial lawyers were a guy named Leo Lucas, a white lawyer from Memphis, Tennessee, and Paul Diamond, a white lawyer from Ann Arbor, Michigan. And on the defense side, it was myself and my partner, Leo Krebs.
I prepared that whole case primarily by myself. We had no paralegals back then, and David was busy doing something else, and he was going to try it. About 3 weeks before the trial was to start, David decided he should get involved in it, and he starts listening to tapes. I swear he's got a photographic memory. I really do, because he picked up everything, kept it in mind, and we went up to Columbus and started trying it. Now we're saving the Dayton Board of Education money by, unheard of, 2 guys staying in a hotel room up in Columbus, which wasn't any bigger than from here over to there, and on the wall we had plastered maps. And we'd prepare for the depositions, and I'd take the daily transcript and get it ready because we knew there was going to be an appeal. So we got ready for the appeal and tried that thing up there, 4 or 5 weeks, and went over the Christmas or the Thanksgiving holiday. The aftermath of the whole thing was that Judge Rubin decided that 3 resolutions, the optional attendance zones, and some other segregated acts constituted, they made it a system that was equal to a segregated system and ordered a remedy. Then we went up to the Court of Appeals and they affirmed it, came back for the remedy, and Judge Rubin appointed the expert, what was his name? Glatt, Charles Glatt.
And you know that story.
I do know that story. It's unbelievable because can you go further into what the courts did at that time? Because what they're trying to do, there's an expert, Dr. Glatt, out of Columbus, if I'm not mistaken.
That's correct, from Ohio State.
Who specialty is to find ways to eradicate and help school districts eradicate purposeful segregation or segregation in general. So Dr. Glatt's kind of the hero to come in and save the day. So things should be able to move forward. We should be able to progress. We won't have this segregated school system again. And want you to let everyone know what happens to Dr. Glatt.
Well, first of all, you're talking just like the Sixth Circuit was talking, which is fine. It's a rational way of looking at it. What happens to Dr. Glatt is one of the great ironies of this case, because we start out talking about how this whole thing erupted in the Dayton riots, which were triggered off by this Neil Bradley Long. Dr. Glad is in my office, and we're having a conversation about what his plans are. A nice gentleman. He had an office in the federal courthouse right next to Judge Rubin's chambers. He leaves my office. He goes back to the federal courthouse. Within 5 minutes, the telephone in my office rings, and the call is that Dr. Glad has been murdered in the federal courthouse. And unlike in the span from the Dayton race riots to that moment in, I think, 75, almost September of 75, from September of 66, from time to time, the same guy was doing the same thing with these drive-by shootings. Right. And they had erupted the other way, so white people driving through the west side were getting shot at too. It was a battle zone.
There's approximately 30 plus people being shot and maybe potentially, right, killed.
But as fate would have it, the murderer of Dr. Glatt was Neil Bradley Long, the same guy that had triggered the Dayton race riots 10 years or 6 years before. Jeez. So off we go. It ultimately goes back to the United States Supreme Court.
Well, we can't skip. I mean, Dave, the guy you just talked to 5 minutes ago, who's going to help smooth over desegregation in Dayton, just gets murdered. We just can't gloss over that without talking about how you felt and what was going on. You weren't scared. You're just like, all right, we'll just keep moving. Like, what do we? You have to feel some type of way.
Well, I've had guns pulled on me from time to time in the course of the
well, your wife doesn't count, Dave. That doesn't count.
The wife doesn't count?
Wife doesn't count.
Well, okay. I had one pulled on me in the federal courthouse. I'd finished a trial down in Cincinnati. And lady comes up to me and says, Mr. Greer, could I talk to you? It was the wife of the plaintiff. And I said, well, sure. And she opens up her handbag, and she's got a big .45 in her handbag. And she says, you know, I've been thinking about killing you all week. And I decided not to do it. And I said, well, I'm glad you told me you're not going to do it, but I'm not sure I really needed to know about the rest of that stuff. But no, obviously it's a shocking thing. Yeah. And it takes all the wind out of your sails when something like that happens. Fine person. Only good thing that came out of it was you can't sneak from the federal courthouse back across the bridge to go to the east side and get away from being captured like he did all these years. He's in a building that's filled with federal marshals, and he just killed somebody in the police right next door to the judge's chambers. So that was the end of Neil Bradley Long's career. Jeez. But it was a horrible thing, and you know, had no impact on the outcome of the litigation.
After Dr. Glatt's death, the district court adopted a desegregation plan, which was approved by the Sixth Circuit, setting the stage for our first trip to the United States Supreme Court. 8 justices heard the arguments. Justice Marshall recused himself because of his involvement with the NAACP. In an 8-0 opinion, the Supreme Court held that the plaintiffs had not demonstrated that segregation in Dayton schools was the result of any action by the school board. On remand, district court dismissed the case, setting up a new round of appeals.
Can you explain to our listeners about the outcome? As we have this ping pong that goes up and down, the district court.
They had other cases that were in the Sixth Circuit, along with the Dayton case. In Detroit, they had a case, and in Detroit, they were busing white students past black schools and busing black students past white schools. Mm-hmm. That sort of thing happened up in Columbus as well. Happened in Cleveland. The Cleveland case ended up with all sorts of things that the board had done that were improper. And in the second trip to the Supreme Court with the Dayton case, it went up in companionship with the Columbus case. Columbus case had worse set of facts. The interesting thing about that argument is when I got up to make it, I looked up, instead of having 8 justices like I'd had the first time around, there were 9 of them there, and there's Thurgood Marshall looking right straight at me.
Wow.
And what happened in that case, it was a 5-4 decision, 4 justices still in favor of the school board. after the first case went back down to the trial court dismissed the whole damn thing. And then, of course, back to the Sixth Circuit and back and forth. But the ultimate decision was the court decided, which is a common sense decision, I think, and a moral decision, whether it's a good legal decision or not. They decided that if schools are segregated, the law should make a presumption that the school board had something to do with it. So that's how it became a case that you couldn't lose, a case that you couldn't win.
With all deliberate speed.
With all deliberate speed. Well, deliberate is a kind of a flexible word.
I think Thurgood Marshall defined that term as slow.
Slow, yeah.
I think when he said that. So, we want to move towards present day. And, frankly, are we experiencing re-segregation?
Frankly, it looks like we are. And frankly, I think if the constituency on the United States Supreme Court in 2022 had been there at the second hearing of this,
wow,
the same thing would have happened.
Right. I think at one point, integration in 1988 saw 37% of black students attending majority white schools. By 2018, that percentage fallen by approximately half. And it's my understanding that Dayton Public Schools specifically harbors approximately 77% African-American students, black students, as we sit here today.
Yeah, one of the sad things about this whole process, from segregation to desegregation to resegregation, and
right.
there's some risk that that's exactly what has happened socially, because there are things you can't stop. I mean, we had both white and black flight,
That's correct.
because the people wanted to get away from the Dayton school system, and that was black people as well as white people.
Black middle class also was leaving.
And of course, a lot of what caused segregation in the schools, some percentage of it is people just like to live with people that are like they are.
Right.
That's just birds of a feather situations. It got exacerbated in Dayton way back at the time of the Dayton flood, because all the WASPs, all the white Anglo-Saxon Protestants, went to up Main Street to what from downtown was the far hills, and moved to the southern suburbs, whereas most of the black families stayed across the river on the west side. There's always been one little group of black families on the east side, way off Linden Avenue. And that didn't change either.
It seems as if, for those who are from or familiar with Dayton Main Street, you've got the west side and predominantly black, and the east side predominantly white, as it's typically described even still today.
Yeah, with various ethnic groups. Back from the old Barney Car Works, when they brought all sorts of people from Central Europe over here to carve those Pullman cars and the bars that you have at Jay's and the Century Bar, and lived in a Kossuth up there in North Dayton. So you've got all these Hungarians and Lithuanians and you name it, kind of scattered around. And there are a lot of Italian and Romanian people on the west side, way out on the west side. But that's, we talk about the Emerald City of the Land of Oz, and there's a part that's red over here and yellow over here. And that's in part just because people do that. In part, it was exacerbated by restrictive covenants and deeds, and in part by redlining by real estate people that you don't want to live there, you want to live here, kind of. But that's pretty much all private action.
Right.
And what can you do about it?
As we sit here today, the Supreme Court's going to be deciding affirmative action case, Harvard versus North Carolina. And it's a case where Harvard's being accused of discriminating against Asian American students by using a subjective standard to gauge traits like likability, courage, and kindness, and ineffectively creating a ceiling for them in admissions. So I would say the latter half of 2023, there's going to be a pivotal decision as it pertains to the affirmative action. With the Supreme Court where it is and what's recently happened in Dobbs, some might wonder if affirmative action may potentially be wiped away, eradicated.
Yeah, in fact, it's almost beyond wondering. I think you and I would both agree on that. It's kind of gotten to be like the Supreme Court's idea is the Groucho Marx had a TV show maybe before your time.
Maybe a little bit.
And it always had a magic word in the show. And if anybody ever said that magic word, a duck dropped out of the ceiling with the magic word in its mouth. And you kind of feel like the way the law is going, the magic word is race. Mm-hmm. And if you say race, we ain't going to touch it.
That's right. Leave it alone. Yeah. At this very moment, there's an article about NFL Dallas Cowboy owner Jerry Jones. And I thought it was, when this came out, there's a picture of him standing amongst a group of white students. And this is when the high school that he was attending in Arkansas, not where the Little Rock Nine were, but another high school where students were attempting to integrate and being intimidated by white students intimidated by white students. And there's this crowd of young white students. Of course, the ones at the front are visibly upset, threatening looks and things of that nature. And then somebody finds out that, wait a minute, who's that guy? And that's Jerry Jones, the owner of the Cowboys, and he's in the back. And the reason why I bring that up is not to discuss his intentions, his emotions. Some people are already saying, oh, he has, I saw some things on, of course, Twitter where you get all the factual information. Twitter said, there's some folks who are saying, he just looks menacing. He looks like he didn't want him there. Others are saying, how can you tell? But he's literally standing there watching and observing, and who knows what's going on in his head. People can speculate. But when I thought that we were probably looking at the wrong thing about what his intentions, what his motives were, but it was the fact that he was standing by and watching, which is kind of interesting with where we are here today.
Because you want to kind of turn that into the Phyllis Greer story that, sorry, Jerry, but you know, there ain't no black cowboys.
Exactly, there ain't no black cowboys.
There actually were. They were Buffalo soldiers.
They're Buffalo soldiers, that's correct.
Be that as it may.
But it was almost kind of like a metaphor for standing back and watching as things take place. And I think Martin Luther King describes and discusses the white moderate and in general, folks who are standing by watching as certain atrocities happen in their communities, in the country, in this world. So,
and we always have strife going on, and you can't avoid it if you're human beings.
Right.
And I have this theory that time heals all wounds and wounds all heals, and that it does deliberate speed. We go through the Civil War and we come out of it with emancipation and the 14th Amendment and the 13th Amendment. And all of a sudden, what happens? 1867, wham, here comes Jim Crow.
Right.
And puts in people a situation worse than slavery.
I find the Jim Crow era is an era which people gloss over because it's easy to look at slavery and say, oh my gosh, that's horrible atrocities. But then you hear emancipation, everybody's okay. But we forget about the vagrancy laws, we forget about the loitering laws, we forget about the laws that were kept in place to make sure that there was a caste system put in place. And that's Jim Crow, where people, I really, when you talk to folks, it's just a period that folks really gloss over until we get to the 60s.
And they really shouldn't, because
they shouldn't, right.
If you've got a slave, you try to take good care of it as you would any other animal that you're dealing with. If you've got somebody that's just cannon fodder, food for forced labor,
like sharecropping,
who cares if you kill them?
Right.
I mean, and that's really what happened in Jim Crow, where we had all the lynchings, we had all these terrible things happening. And only time can really solve these problems.
Yeah, absolutely, absolutely. So, how have you seen the litigating cases such as this seems to be difficult because one of the standards in order to prove discrimination, and particularly I've had discrimination cases that have been tried before me, is the intent to discriminate. And proving the intent to discriminate is very, very, very difficult. It's a very, very high standard. And I think the Supreme Court even wrestled with this during parts of not just Brown versus Board of Education, but the Dayton desegregation cases. And I think when folks think of intentional segregation and racism, the first thing they think of course, is lynching. They think of slavery. They think of burning crosses in somebody's yard. The pictures that we've seen from the 60s But it's a very, very difficult standard to prove. I mean, you've been in federal courts quite some time. I know you've had some of these types of cases, but is that something that, if we're always going to have this standard, the intent to discriminate, then there's always going to be this cloak that you can hide behind?
It's a very tough job. Well, and you get it every time you try a criminal case that
Absolutely.
involves a black defendant.
Yeah, absolutely.
Because one side, the defendants are going to have black people on the jury, and the prosecution's probably going to want to have off
Right.
the jury. That just
Absolutely.
you play to win, and
Right.
that's the way you win.
That's the way you win, yeah.
And you get the awful thing of, can you
Intention.
give me a neutral reason why you want to knock Mr. or Mrs. So-and-so off this jury panel?
Right.
And you get it every time you try a case, I expect.
The old Batson challenge.
Yeah.
You know, the old Batson challenge comes every now and then to kick someone off the jury panel that is either favorable or unfavorable. However, you can find a reason as to why they may be race neutral or not. You know.
But as we think of the grimness of going from a segregated society to a desegregated society, and the risk of getting back into a resegregated society,
Right.
on the bright side,
Yes. Can we get there?
yeah, I think we are there. I live in the Oregon district. We're black, white, we're genders of every thing the human mind can imagine,
Right.
all living happily side by side. And it's a beautiful thing. And I think we're seeing more of that in the next generation.
Right. And you can't let these Neil Bradley Longs that are out here discourage
And
that, 'cause
unfortunately,
they're out here.
all you got to do is turn on your TV set, and it looks like Neil Bradley Long is alive and well.
Yeah.
But he's in a minority.
Yeah, absolutely. Absolutely.
Primo Levi, who wrote about all the Holocaust stuff, said, there really are monsters, but there are not really very many of them. The people who do bad things are often people who just don't think, and they are in a routine, and they follow like sheep or whatever everybody else is
Right.
doing. And
Absolutely.
as long as you depersonalize other human beings, then trouble's brewing.
Right. Did you feel as if, and I guess, do you feel as if there are ways in which we can continue to try to further assimilate in the school system? Is there anything that you've seen, like I said, in the school district that my daughters go to, still predominantly white, and then parts of course, Dayton Public School predominantly black, but then there's still schools that seem way more integrated probably now than, of course, before when my mom went to school and things of that nature. But is it going to take continually to know, getting to know somebody who's not in your orbit, getting to assimilate with somebody who may have different views as far as politically, religious, socio-economics, sexual orientation, things like that?
Well, I think we've had one school success story in the Dayton school system with Stivers,
Yeah.
which is a magnet for creative people.
Right.
And it's just been a glowing success in what otherwise has not been a very glowing success.
Absolutely.
My idea when the whole fool thing started in '72 was, my plan was we keep the neighborhood schools for the little kids so that they can go with their neighbors and friends and so forth to school and so forth. And then we just have one high school for the whole, damn city. And at the time, they were building Sinclair College, and on the other side of the 3rd Street Bridge was an Oldsmobile dealership and plenty of land. And I thought, you could just build one high school there, and it would have every subject you could imagine. That was my pie in the sky idea, which got shot down pretty quickly.
Yeah.
And you go to the Jerry Jones thing, one of the reasons it got shot down is, hey, if we do that, won't be any white kids able to play basketball.
That's true. I mean, that's a part. Dave, I have to ask you, followed this case up and down from Ohio District Court to 6th Circuit to the United States Supreme Court, then back down, and then back up, and then back down. What did you learn from all of this?
I think I learn something every day, and no matter what I do, but I think what this teaches me, and hopefully other people to some extent, is that the law is an adversary system the way it works. People get mad at lawyers because you're representing who they think is the bad guy instead of the good guy.
Right.
But that's the job of lawyers. And the idea is that the truth will ultimately emerge in a clash of ideas.
Right.
And that's the job of a lawyer, is to be part of that clash of ideas. And it seems to me that the law is always groping for the right solution. Sometimes the right solution is not the legal solution.
Right.
And that's what happened here.
Absolutely.
I mean, the right solution legally, I think, was what happened the first time up there.
Of course.
But the law gropes forward, and morality kind of smooths it out. And if you can get the right result, which is what a human being feels in his or her gut,
Right.
then, okay, you put a presumption in that makes it work that way.
Absolutely. Fantastic. If you want more information about all the things we've discussed and getting more information from our attorney and legal historian, Dave Greer, read about these cases in David's book, Slough of History's Boot Soles. In the next episode of Retrial Podcast, we will discuss the antitrust case between department store giants Reichs and Elder Beerman. Dave, you're involved in that as well, right?
I was, yeah.
And how they left downtown for the suburbs, like many have as well. Personally want to thank as well this Dayton Bar Association and Dayton Bar Foundation project was funded in part by a grant from Dayton Legal Heritage Foundation of the Dayton Foundation and by a grant from the Jack W. and Sally D. Eichelberger Foundation of the Dayton Foundation. So thank you all for that. Dave, this was fun. Got a lot more work to do.
Fun for me.
This was fun, man. This is a 6-episode pilot podcast, and with your support, we can find funding for future episodes. Support us by subscribing, leaving a review, and comment.